Welcome back to the video lecture on East Asian state leadership in international law. This time, we are going to talk about a very fundamental question, which is does Asian international law exist or no Asian approach to international law? This will be the most significant questions we are going to discuss this time. The first, please talking about the necessity for Asian international law. The questions we have like does Asian international law exist? If it exists, how does it manifest itself? This scholarly inquiry into the existence and nature of Asian international law has yielded negative outcomes when analyzed through the lens of domestic legislation processes and state practice. It is easy to point out and identify the essential issues of the international law practices of the countries in Asia. While identifying crucial issues in international practice of Asian nations is straightforward, a comprehensive understanding demands the conceptualization, materialization, and practical application of these issues. Until concrete results emerge from its ongoing discourse, the true essence and implication of the Asian international law, distinct from Europe-centric international law, will remain unanswered. The question remains open as to whether a distinct Asian approach to international law truly exists. Alternatively, one could contend that there exists a nuanced and subtle concept of Asian approach within that the context. The divergency of the approaches in Asia and diversity of approaches in Asia making challenging to delineate a singular, definitive, or overarching Asian approach to international law. The Asian approach to the law of the sea, for example, is shaped by a combination of national interests, political constraints, and cultural influences. The economic, the security, and territorial concerns that drive the national interest, while domestic and international political factors play a significant role. Additionally, the regions, the historical cultural interactions contribute to as distinctive maritime practices. Understanding these multifaceted dynamics is crucial to grasping the East Asian perspective on the law of the sea. The notion that Asia is predominantly by a norm taker rather than norm maker has been ingrained within the region's collective consciousness. This perspective is influenced by the historical and geopolitical factors that have shaped Asian interactions within the global order. While it is true that there exists a considerable number of international lawyers in Asia, their overall presence and impact on the international legal landscape are not as extensive as in other regions. Promoting close cooperation among international lawyers in Asia is of paramount importance in challenging and prevailing perception of Asia as a mere norm taker. By fostering collaborations and dialogue among legal experts in the region, a deeper understanding of the diverse legal traditions, the perspectives, and contributions Asian states can be cultivated. These collaborative efforts can unveil the potential for Asia to emerge as a norm taker rather than passive recipients of the established norms. One avenue of achieving this objective is to encourage research and scholarly engagement that explore the unique legal viewpoints and approaches adopted by Asian states. By delving into the historical cultural underpinning of the Asian legal systems, international lawyers can identify instances where Asia has played an active role in shaping global norms and legal principles. Moreover, multilateral forums and institutions in Asia offer opportune platforms by fostering cooperation among international lawyers. By facilitating exchanges of ideas and expertise, these forums can facilitate to reevaluation Asia's role in international law and enhance the region's collective voice in shaping the future global legal norms. Emphasizing Asia's potential as a norm maker rather than norm taker also underscores the significance of diversity in the international legal landscape. Recognizing and embracing the varied perspective and experience of the Asian state can enrich the global discourse on legal matters and contribute to more inclusive and equitable legal framework. The promotion of the close cooperation among international lawyers in Asia is very vital to challenge the perception of Asia as a mere norm taker. By fostering collaboration, recognizing Asia's diverse legal traditions, and exploring region's contribution to international law, the more accurate and comprehensive understanding of Asia's role as a potential norm maker can emerge. This reevaluation will not only enrich global legal discourse, but also empower Asian states to actively shape and influence the development of the international legal norms. In conclusion, the question of whether Asian international law exists or whether there is a distinct Asian approach to international law remain a subject of the ongoing debates and exploration. The diverse culture and history and geopolitical context within Asia have undoubtedly shaped the attitude and practice of Asian states in the realm of international law. The dynamic and multifaceted nature of the Asian region, with its diverse culture and history and geopolitical interests, make it challenging to paint the monolithic picture of Asian states, the attitude and practices in international law. While some scholars argue for the presence of a unique and coherent Asian approach, others emphasize the heterogeneity of the perspective and practice across the region. The evolving role of Asian states in global affairs, along with their increasing engagement with the international organizations and treaties, suggests a growing importance of international law in shaping their interactions. However, it is crucial to recognize that any Asian approach to international law must be approached with caution, given the region's diversity and complexities. As the international states continue to navigate their interests, engaging in dispute settlements, and participate in international fora, further scholarly inquiry will be essential to discerning and understanding any distinct characteristics or commonalities that may define Asian international law. It necessitates a nuanced analysis that takes into account the interplay between domestic interests, regional dynamics, and global ambitions. Unraveling the intricacies of the Asian international law demands rigorous academic inquiry that delve into cultural, historical, and geopolitical intricacies to shaping regions' engagement with the international legal order. It is noted that while many speak of the need for Asian perspective in international law, only a few have articulated about how it could be actually realized. This indicates that there is no fully developed conception of what an international perspective international law is. For its part, it is emphasized that there should be a meticulous analysis of the key issues that Asian states face in relation to international law if there is to be thoughtful engagement in ascertaining what an Asian perspective of international would be. This means that the key to developing Asian perspective would be to counter or uncover the materials on international practices and developments from Asia. The use of the mainstream Western-produced international textbooks, which is very little or non-coverage of the Asian states and their practice and interest, the phase to prove and educate the Asian context of the international law. On the methodology of such an endeavor, it is suggested that Asian scholars should first focus on their home state jurisdiction to identify the pertinent international legal issues that have arisen along narrow topical lines. Here, it would be essential to identify the state practice and to as faithful to the methodology of empirical study as much as possible. The next, scholars should then conceptualize the issues arising out of state practice they have identified, then materialize the conception that they have developed through drafting of the scholarly works on the topic. Fortunately, a number of Asian journals avenues for publication have increased, and scholars should seize the opportunity that these venues provide the enhancing discussions and dialogues to advance what Western scholars might classify as outsiders' perspective to international law, which are currently not present with the mainstream international textbooks. Finally, they should utilize these materials by sharing and collaborating with other Asian scholars. Only in this way can the Asian perspective on international law be efficiently and collaboratively identified and developed. Thank you very much for your attention.